Good evening and welcome to Courts Today by LiveLaw. I am Urvashi Chauhan, and in this video we cover some of the top legal updates from across India. The Supreme Court has directed Telangana Speaker to act on BRS MLAs disqualification, while a Mumbai NIA Court has acquitted all accused in the 2008 Malegaon Blast case. We also discuss Kerala High Court's stay on euthanizing stray dogs, Delhi High Court's concerns on civic apathy during floods, and Jharkhand High Court's action on enforcing the beef ban. Plus updates on ED case statistics and new entry rules for law interns at the Supreme Court. Watch till the end and make sure to subscribe and hit the bell icon. In a significant verdict delivered by the Supreme Court today, it has directed Telangana's Legislative Assembly Speaker to decide within 3 months the disqualification petitions filed against 10 BRS MLAs who defected to the Congress party. In case you do not know, 3 BRS MLAs, namely Venkata Rao Tellam, Kadiyam Srihari and Danam Nagender, defected to the Congress post the 2023 Assembly elections. Disqualification pleas were filed by BRS MLAs Kuna Pandu Vivekanand, Kaushik Reddy and BJP MLA A. Maheshwar Reddy, alleging delay by the Speaker was enabling more defections. In September 2024, a single judge bench of the Telangana High Court directed the Speaker to fix a schedule for hearing the pleas within 4 weeks. But in November 2024, the division bench reversed this, stating that the Speaker must act within a reasonable time but not under judicial directions. Well, now a bench comprising Chief Justice of India B.R. Gavai and Justice A.G. Masih held that continued delay in adjudicating the petitions would defeat the very object of the anti-defection law under the 10th schedule of the Constitution. The court criticized the Speaker's inaction for over 7 months, noting that no notice was issued on the disqualification petitions during this time. It warned against a repeat of the widely criticized situation of Operation Successful but Patient Died, where delay allows defecting MLAs to enjoy the fruits of office while their disqualification remains pending. It said that the Speaker, while acting as a tribunal under the 10th schedule, does not enjoy constitutional immunity, and the court is empowered to issue directions to aid expeditious disposal. The MLAs facing disqualification must not be allowed to delay the proceedings. If they attempt to do so, adverse inference may be drawn against them. In a powerful remark, the Supreme Court urged the Parliament to reconsider whether speakers who are often political appointees should continue to be entrusted with deciding disqualification petitions. It said that if the very foundation of our democracy is to be safeguarded, it must be examined whether the present mechanism is sufficient. This suggestion was prompted by the recurring instances of speakers delaying decisions on disqualification petitions, allowing the matter to remain pending till the expiry of the term of the Assembly, thereby enabling the defectors to escape scot-free. In a major development, a special NIA court in Mumbai has today acquitted all 7 accused in the 2008 Malegaon bomb blast case, which had claimed 6 lives and injured over 100 people. The verdict was delivered by Special Judge A.K. Lahoti, bringing an end to a high-profile trial that spanned nearly 17 years. The blast took place on 29 September 2008 near a mosque in Malegaon, Maharashtra. A bomb strapped to a motorcycle went off shortly after Ramzan prayers, triggering communal tension. Initially investigated by the Maharashtra Anti-Terrorism Squad under Hemant Karkare, the case led to the arrest of 12 individuals, including BJP MP Pragya Singh Thakur and Lieutenant Colonel Prasad Purohit. The ATS alleged that the accused were linked to the right-wing group Abhinav Bharat and were motivated by a desire for revenge. The ATS filed its charge sheet in 2009 under various laws, including Maharashtra Control of Organized Crime Act, commonly known as MACOCA. In 2011, the National Investigation Agency took over the probe. While the NIA initially opposed bail, by 2016 it dropped charges against Pragya Thakur, citing lack of evidence and alleging that ATS had coerced witness statements. However, the court refused to discharge her, relying on materials submitted by the ATS. The trial commenced in 2018 with 7 of the 12 original accused facing trial under UAPA, Explosive Substances Act and other laws. Over 300 witnesses were examined, with several turning hostile. The accused included Pragya Singh Thakur, Lieutenant Colonel Prasad Purohit, retired Major Ramesh Upadhyay, Ajay Raherkar, Sudhakar Dwivedi, Sudhakar Chaturvedi and Sameer Kulkarni. In April this year, arguments were concluded and the verdict was reserved. And today, the court acquitted all 7 accused, clearing them of all charges. Let me tell you here, this case has witnessed several controversies, including changes in prosecutors and public allegations. In particular, former Special Public Prosecutor Rohini Salayan had alleged that NIA officials asked her to go soft on the right-wing leaders booked in the case. Moving ahead, in a telling revelation about the effectiveness of Prevention of Money Laundering Act or PMLA, the union government has informed the Rajya Sabha that in the last 10 years, that is from January 2015 to June 2025, only 15 persons have been convicted in 8 conviction orders. This information was provided by Union Minister of State for Finance Pankaj Chaudhary in response to a question raised by Trinamool Congress MP Saket Gokhale. Gokhale had sought data on PMLA cases in which charge sheets were not filed and trials had not commenced since 2015. According to the government's reply, Enforcement Directorate has investigated 5,892 cases under PMLA during this period. However, prosecution complaints, essentially charge sheets, were filed only in 1,398. Including 353 supplementary complaints. Out of these, charges were framed in just 300. So in other words, only 24% cases by ED make it to investigation, and out of that, only 5% make it to the trial stage. ED also filed closure reports in 49 cases, meaning they did not find enough material to proceed further. This data becomes even more significant in light of repeated concerns expressed by the Supreme Court about low conviction rate under PMLA. In December last year, the government had shared that between 2019 and 2024, the conviction rate in PMLA cases stood at just 6.4%. While hearing a bail plea in a money laundering case linked to coal transportation, a bench of Justices Suryakant, Dipankar Datta and Ujjal Bhuyan had remarked that poor prosecution standards had led to poor conviction statistics. In yet another hearing, during the bail plea of former West Bengal Minister Partho Chatterjee, the court asked how long under trials could be kept in jail when ED's conviction record was so weak. The same concern was raised in Arvind Kejriwal's case, when the Supreme Court observed that the data on ED's arrests and PMLA complaints raised serious questions, especially given how long many accused persons remained in custody without a trial. Justice Ujjal Bhuyan, speaking at a public event recently, also remarked that courts must follow the constitutional principle that bail is the rule and jail is the exception. He added that the abysmally low conviction rate under PMLA is a compelling reason to not keep people in prison for long periods without trial. The Kerala High Court has temporarily put a stop to the government's plan to euthanize stray dogs under the controversial Prevention of Cruelty to Animals, Animal Husbandry Practices and Procedures Rules 2023. The order came while hearing a batch of petitions related to rising number of stray dog attacks in the state. Justice C.S. Dias passed a common interim order staying Clause 9 of the Kerala government's order, which had cited Rule 8 of the 2023 rules. That rule allows for euthanasia for animals in 2 scenarios. First, if a vet certifies that the animal is either mortally injured or so diseased that keeping it alive would be cruel. And second, if a government authority believes the animal poses a public health risk by spreading disease. But the court said not so fast. It referred to previous judgments, including the Kerala High Court's own ruling in Ajayan M.R. versus State of Kerala and the Supreme Court's ruling in Animal Welfare Board of India versus People for Elimination of Stray Troubles, to hold that implementing Rule 8 in this manner cannot be allowed for now. The court acknowledged that striking a balance is necessary between animal welfare and public safety, but that balance, it said, must follow due process and constitutional norms. Quoting Article 21, the right to life and dignity, court said that animals must be treated humanely, but also noted the Supreme Court's 2023 ruling, which clarified that animals do not have fundamental rights, even though the state has a duty to protect their welfare through laws. The court has now directed several top officials, including the Principal Secretary of the Local Self-Government Department, the State Police Chief, and the State Disaster Management Authority to submit detailed reports. These must include data on stray dogs dog bite cases, relevant criminal cases under the Bharatiya Nyaya Sanhita, and compensation schemes for victims of animal attacks. The matter will now be heard further after these details are submitted. Stay tuned. In another update, the Delhi High Court has come down heavily on the disorganized civic response to flooding and drainage issues in the national capital. Expressing concern over the enormous confusion among civic agencies, the court has directed the Delhi government to consider centralizing the administration and management of flood-related responsibilities. A division bench of Justices Pratibha M. Singh and Manmeet Preetham Singh Arora observed that essential services like drainage system in city are suffering due to a lack of coordination among multiple government agencies. The court noted that agencies such as the MCD, PWD, Delhi Jal Board, Irrigation and Food Control Department and the DDA often end up passing the buck due to unclear division of responsibilities. The result: widespread waterlogging and blocked stormwater drains. However, the court also acknowledged that the blame does not lie solely with the government. In many colonies, it pointed out residents themselves contribute to the problem by constructing cement pathways over storm drains, leading to their constant logging. Calling the situation a result of systemic apathy, the bench said that the time has come for the Delhi government to take a comprehensive decision on how civic services in Delhi should be managed and administered more efficiently. The order has now been sent to the Chief Secretary of the Delhi government with the direction to place it before senior functionaries and, if necessary, even before the Lieutenant Governor to explore the centralization of flood management responsibilities. The court was actually hearing a plea filed by 14 families residing in Juggies near the Tamur Nagar drain close to Maharani Bagh. The families are seeking rehabilitation or alternate accommodation before any eviction or demolition by the special task force which has been empowered by the court to remove encroachments for drain expansion. The next hearing in the matter is scheduled for 19th August now. The Jharkhand High Court has asked the Director General of Police to personally file an affidavit detailing the action taken to enforce state's ban on bovine slaughter and meat sale, especially in markets like the Qureshi Mohalla in Doranda, Ranchi. A bench led by Chief Justice Tarlok Singh Chauhan and Justice Sujit Narayan Prasad was hearing a public interest litigation seeking a ban on illegal culling of animals, including poultry, and the public display of animal carcasses on the streets of Ranchi. Back in 2024, the petitioners had flagged open sale and slaughter of bovine animals in Qureshi Mohalla, alleging that cow meat was being sold in broad daylight in clear violation of Section 12 of the Jharkhand Bovine Animal Prohibition of Slaughter Act 2005. The court had earlier directed the Senior Superintendent of Police Ranchi to explain why no action had been taken to curb these illegal activities and why this information was not submitted to the court in earlier hearings. Now the court made it clear that it wants accountability from the top. The Director General of Police must now submit a personal affidavit on the steps taken to implement the court's directions, especially those passed in August 2024. In addition, the state has been asked to clarify whether the 2005 Act is being violated anywhere across Jharkhand, if slaughterhouses are mandatory within municipal limits, and whether small vendors can be allowed to slaughter animals. There are some more inquiries, like whether illegal slaughterhouses are operating in the state and whether slaughterhouses are regularly inspected with records to show, etc. The court has also asked for data on how many cases have been registered under Section 12 of the 2005 Act and whether any action has been taken against the officer in charge of Doranda Police Station where these violations allegedly took place. The matter will now be heard again on 26th August. Stay tuned. And now an important information for the law students and law interns. Starting this week, law interns will no longer be allowed entry into the Supreme Court on Mondays, Tuesdays and Fridays, the designated miscellaneous days where the court typically sees heavy footfall and a packed cause list. This restriction follows a formal request by the Supreme Court Bar Association, which wrote to the court on 23rd July, raising concerns about overcrowding. The SCBA flagged that on these high traffic days, interns often occupy courtroom seats, sometimes refusing to vacate them, even when asked by senior members of the bar. This, they said, was hampering the function positioning of lawyers, especially senior advocates. Acting on the request, the Assistant Registrar of the court has now issued instructions restricting intern access on these days. However, interns will still be allowed entry on regular hearing days, that is Wednesdays and Thursdays. This move aims to strike a balance between providing court exposure to law students and ensuring smooth proceedings for practicing lawyers on the busiest days.